Yes, yes, Neha, Pooja, and am I audible to all of you? Am I audible to all of you? Kindly please let me know. Yes, I am audible. I mean, yes, Nitin. I mean Nitin Rajiv. You see, so I am visible and audible both. I hope so, Mr. Rajiv. I am visible and audible both. I hope so. Yes, you are visible, sir, and I am audible also. So, should I start? Should I start? Yes, please let me know. Yes, please start, sir. You see, and to begin with, my first of all, I sincerely thank to this, I mean the office bearer of the management committee of this institution to have arranged an online session on constitutional law or some of the topics of constitutional law. You see, this is Pahuja Law Academy, and in short, I mean Pahuja Law Academy. In short, I would like to say only two things about this academy. You see, for the last several years, slowly and gradually, this academy has become a brand in itself. You see, this academy has become a brand in itself, and during the last several years, it has covered a massive result in almost all the states of our country. We are providing both online and offline session and the hybrid session also. So this is one aspect of the matter. Second, I am myself Vijay Kumar Sinha. I mean teaching the students for the last several years, say about 20 years, you see. So last several years, and teaching constitutional law, jurisprudence, I mean international law, administrative law, and above all, you see, and above all, I mean the most important aspect which I have been teaching for the last several years, you see, that is, I mean the entire general awareness program. And this is the only institute which provides the general awareness program, you see. General awareness program is an integral part of, I mean the all the competitive examinations, you see, today, especially judicial officer examination, you see. So, and for a moment, let us, I mean we are going to share, in this connection, we are going to share my, I'm going to share my experience today. The topic today that was provided, the topic, before I could start with the, straight away start with the topic concerned, you see, one important, suggestion I would like to give the students, all the students who are hearing me, you see. Whatsoever the law paper may be, in constitutional law, you have to take into account three important things. In constitutional law, you have to take into account three important things, you see, three important requirements, especially for studying constitutional law, the mode and method of studying constitutional law, you see. One is that you should be conversant with, I mean, the relevant important constitutional provisions. This is one. Relevant important constitutional provisions. Relevant important constitutional. So, I mean, it is suggested, it is frequently suggested that the student should keep the bare act or bare text always with them, you see, because you have to develop the chapter on the basis of the relevant constitutional, basic constitutional provisions. This is the first primary, I mean, this is the first primary requirement and primary suggestion, you see. Second, the second important suggestion is the reference to, is the frequent reference to the important, I mean, case laws, you see. The important case laws, you see. Case law, when I say case law, I mean there are three categories of case law, you see. One is, I mean the case laws, case title of 2023. The second is the case title of 2022. And the third one is equally important. I mean the old landmark judgments, you see. Old landmark judgments. So while studying, I mean the constitutional provisions and the, I mean, concerned chapter therein, you see, and the concerned chapter therein, you are required, you see. And the third, last but not the least, and the third important suggestion is that you should develop the habit of, I mean, connecting the different chapters, you see. You should develop the habit of connecting the different chapters with the current aspects, you see. With the current, I am going to cite you here also on this topic of one current aspect, you see. You should develop the habit of, I mean, connecting. You should develop the habit of connecting. And am I audible? Yes, Nitin, Rajiv, I think I am hopeful. Am I audible to all of you, you see? Yes, yes, sir. So, the third, I mean, important requirement is, you see, that you should connect your chapters whatsoever. You should connect your chapters with the, I mean, current aspects of, I mean, the national and the international scenario also, you see. These are the three basic requirements, you see. These are the three basic requirements. Now the topic is, I mean, today's topic is right to freedom of religion. I have taken one topic, right to freedom of religion, as suggested. Now, right to freedom of religion, when you start with, in the light of these three suggestions which I have just given to all of you, you see. Right to freedom of, I mean, right to freedom of religion. So there are different, you see, there are different aspects of right to freedom of religion, you see. One aspect is to locate, first of all. So when you start with this particular chapter in part 3rd of the Indian Constitution, you see, you should first locate, I mean, the basic philosophy behind right to freedom of religion, you see. I mean, as an important part of part 3rd of the Indian Constitution, you have to locate, you see. You have to locate, I mean, the basic philosophy behind this right, you see. And the basic philosophy is to be traced in preamble to the Constitution of India. So first of all, you should mention, I mean, the relevant philosophy in the preamble to the Constitution of India. Now the preamble to the Constitution of India, if you see, there are four, if you see the nature and content, if you see the nature and content, before I could connect it, if you see the nature and content of preamble to the Constitution of India, there are four, I mean, important parts of there are four important parts of the nature and content of preamble to the Constitution of India, and how it is associated with this particular right, that I'll be explaining to all of you. You see, one is the source of power. I won't go into the detail, you see. One is the source of power. I'm just mentioning the connection, you see. One is the source of power. The other is the nature and type of political system. We the people, having solemnly resolved to constitute India into sovereign, socialist, secular, democratic republic, you see. So there are four adjectives of republic here: sovereign, socialist, secular, democratic republic. So second, point is the nature and type of government, you see. The nature and type of government, you see. Sovereign, socialist, secular, democratic republic, you see. Now, the philosophy, first of all, this philosophy, this nature and content includes the word secularism. Secular word is added, you see. एक तो ये base हो गया. The word base, the base is provided in the, nature and the type of government: sovereign, socialist, secular, democratic republic, you see. Secular, this word secularism, this word secular, sovereign, socialist, secular, this word secular was added by 42nd Amendment, as you all know. Adding this word is not that the new word, philosophy has been added. It was already there, you see. Adding this word secular was a kind of clarification only. It was a kind of clarification, you see. We have not added something very new, you see, because already, the ideals of secularism was already there in the goals of the nation, you see. So one basis, the one important basis is to be found in this added word, that is secular or secularism, whatsoever you can call it, you see. And the second is to secure to all its citizens. Now, to secure to all its citizens justice, social, economic and political, you see. Justice, social, economic and political, and a liberty, and a justice, social, economic and political, you see. Liberty of thought. Now you see, just keep into mind liberty of thought, expression, belief, faith and worship. So the whole philosophy behind right to freedom of religion is to be found in this line, you see. This is the objective, you see. This is one of the goals. This is one of the goals of the nation, you see. This is one of the goals of the nation, and that is liberty of thought, expression, belief and worship, faith and worship, you see. तो आप कह सकते हैं, you can start with that the addition that this right to freedom of religion, which is provided in particular provision that I'm going to explain to all of you, has its base, philosophical base, in liberty of thought, expression, belief, faith and worship. It's not that something new has been added in part 3rd of the Indian Constitution. तो एक तो आप इस पॉइंट को सामने रखेंगे और कहेंगे that this is the philosophical base of the right to freedom of religion. एक तो दिमाग में ये रखें आप to begin with. Second, there is a recent judgment, you see. And you must be knowing also, it's not that I'm completely, citing a very recent, example, you see, which you may not be knowing, you see. It's not that. This is known to everybody, you see. But in this connection, what is required that you should start with this, the recent Supreme Court, verdict. You should start with this recent Supreme Court verdict, and this verdict is Aishat Saifa versus State of Karnataka, you see. तो मैं जब लिखूंगा, when I will start writing, I will start with this current aspect, you see. Connect करो इसको. You have to connect it. Aishat, AISHAT, Aishat Saifa versus State of Karnataka and others. State of Karnataka and others 2022 का केस है, you see. Now in this case, the controversial subject matter was, hijab, you see. Now the verdict was, on this issue, the verdict was a split verdict, you see. As you all know, what is important in this connection that I am going to explain to all of you, you see. The verdict was a split verdict, you see. And the split opinion, due to this split opinion, the matter was referred before the CJI. The matter was referred before the CJI to be referred to a larger bench, you see. Currently, Karnataka and Rajasthan, for your kind information, Karnataka and Rajasthan has now become a hotbed of, this controversy regarding hijab, you see. Some of the students consider that this is against the right to freedom of religion, you see. This, banning hijab is against the right to freedom of religion. But some of the, students are of the opinion that this is not against right to freedom of religion, you see. So naturally, in this connection, whenever you start with studying right to freedom of religion, start with this 2022 case, you see. Actually, this liberty of thought expression, belief, faith and worship, or this right to freedom of religion, has been translated, you see. For your kind information, has been translated in two categories of constitutional provisions, you see. Has been translated in two categories of constitutional provisions, you see. दो कैटेगरी ऑफ कॉन्स्टिट्यूशनल प्रोविजंस में आप जरा सा इसको देखें. दो कैटेगरीज ऑफ कॉन्स्टिट्यूशनल प्रोविजंस में, है ना, दिस इज, तो दो कैटेगरी ऑफ कॉन्स्टिट्यूशनल प्रोविजंस को आप देखिए. दिस इज कैटेगरी नंबर 1 एंड दिस इज कैटेगरी नंबर 2. एक तो कैटेगरी हो गया, this is article 25 to 28. This is article 25 to 28, you see. 25 to 28. तो एक तो ये हो गया constitution. This is one constitutional set of, this is one set of constitutional provisions. So the philosophical base, what I am trying to say, so the philosophical base and a liberty of thought expression, belief, faith and worship, एक तो यहाँ पर इसको translate किया गया, and that is in between article 25 to 28, you see. This is in between article 25 to 28. और दूसरा जो the second set is, the second, ये second set हो गया. This is second set of provision. तो सेकेंड सेट ऑफ प्रोविजन में, the second set of provision, naturally 14, 15 and 16. 14, 15 and 16, 29, 30, 29, 30, 325 and 44. Yes, second set, दो set पर. So you have to understand the right to freedom of religion in the garb of two important constitutional, set of provisions, you see. Two set of provisions, you see. So, this controversy related to hijab has to be tested. In the context of these two set of provisions, you see. टू सेट ऑफ प्रोविजंस में पहले तो आप यहाँ पर जब उतरते हैं तो रेलिवेंट वन इज 25 क्लॉज 1 एंड 25 क्लॉज 2 ए एंड बी. ये प्लीज काइंडली कम टू, दिस इज द मोस्ट इंपॉर्टेंट वन. 25 क्लॉज 1 and 25 clause 2a and b. If you have the bare text, that's why I told you, you see, the first requirement is to keep the bare text with yourself. Bare text तो आपके लिए बाइबल है, you see, because these are the evidences, you see. चूंकि I am a student of, current awareness program also. The students, you see, the law students, I must tell you in this connection, the only, limitation of the law students are that they are not aware of the general awareness, general knowledge. They are not properly and they don't take interest, you see. It should be treated as a paper. Since I have been teaching the students for the last several years this program also. अब यहाँ पर आप देखिए ना, है ना, मान लिया हमने इसमें 14, 15 सेकेंड जो सेट है, you see, 14, 15, 16, है ना, 29, 30, 325 एंड 44. तो जैसे उदाहरण के तौर पर इधर एक एग्जाम्पल 44 का हो गया, तो यहाँ तो करंट पूरा 44, concerned with Uniform Civil Code, which is today, a constitutional, a great issue today, in view of the, cabinet resolution and passing of UCC bill in Uttarakhand. तो 25(1), Article 25. तो come to the first important aspect of, you see, 25 clause 1, 25. Yes, no, yes. Am I clearly audible to all of you? Yes, Neha, am I clearly able to, am I visible and audible? You see, Puja, you just let me know also in course of lecture. Yes, तो आप देखिए फर्स्ट वन इज 25. यस, ऑडिबल सर. तो कह रहा है दिस इज 25 क्लॉज 1, यू सी, दिस इज 25 क्लॉज 1. तो 25 क्लॉज 1 को आप जरा सा देखिए, है ना, इसमें दो चीज है. first of all, it includes, precisely first of all, it includes 4 important parts, you see. First of all, it includes 4 important parts. इसलिए जब भी आप कॉन्स्टिट्यूशनल लॉ का क्लास कर रहे हैं तो कम से कम बेयर टेक्स्ट को सामने रखेंगे. अब फर्स्ट ऑफ ऑल इट इंक्लूड्स, यानी आर्टिकल 25 द कॉन्स्टिट्यूशन गारंटीज द फॉलोइंग फ्रीडम्स टू ऑल द पर्संस. यू सी, 4 है. there are 4 parts, important parts, you see. First one is right to freedom of conscience. Conscience means inner freedom. Freedom of conscience means inner freedom of a person. Inner freedom of a person to mold his relationship with God. Inner freedom of a person to mold his relationship with the God. In whatever manner he likes, you see. The second, important part is right to profess, you see. The second important part is right to profess, जिसका मतलब है, it means the right to declare freely, the right to declare freely and openly one's faith. तो यही ना philosophical basis. This is the philosophical basis in preamble. Liberty of thought, expression, belief, faith and worship. The third part is right to practice. That is to perform religious duties. Right to practice, that is to perform religious duties. Religious duties, rites, rituals and ceremonies, you see. And the fourth part is right to propagate, you see. And the fourth part is right to propagate. Propagate means to spread. Propagate means to spread and publicize one's religious views. Now there is a case, you see. Right to propagate, involves a very important case law. Case law का नाम है Reverence Stanislaus. Reverence Stanislaus versus, state of Madhya Pradesh. Reverence Stanislaus, Stanislaus versus Madhya Pradesh 1977, and wherein the Supreme Court categorically, observed that right to propagate does not include right to convert. Right to propagate does not include right to convert a person to his own religion, you see. यानी आप देखिए तो these rights are provided. Now kindly see, ये जो issue है हिजाब, whether it is constitutional or not a constitutional proposition, you see, this has to be tested in the light of, this first set of provisions, you see. मैं बहुत दिन से चैनल में डिबेट पढ़ता हूं, लेकिन किसी ने इस बात को पॉइंट आउट नहीं किया है, you see. लेकिन आप देखिएगा 25(1) में, in Article 25, Clause 1, this is what in Hindi we call 25(1), you see. I'm sorry, I have spoken Hindi also. Whether you are knowing Hindi properly or not, I don't know. But then this is 25, Article 25, Clause 1, you see. Now these rights are 25 Clause 1 को आप ये please kindly see. These rights are not absolute. It is subjected to two restrictions. It is subjected to two restrictions. One is, restriction of public order, morality and health. Public order, morality and health. And public order, morality and health. And second is restriction provided in other provisions of this part. other provisions of this part means other provisions of part 3. There is a limitation, otherwise I would have been talking with the students directly. This second restriction is actually talking about, you see, is actually talking about the reasonable restriction and provided in Article 19(2) to 6. Subjection clause refers to two restriction. One I have said, the second I have said. Relating to fundamental rights, you see. Yani your following freedoms are subjected to these two restrictions. अब इसको आप किस रूप में देखते हैं, 19(2) to 6 देखेंगे, जरा सा उसका वाइड स्कोप देखेंगे. There is a limitation on webinar, there is a limitation of time, you see. There is a limitation of time, you see. And the second is Article 25(2)(a) and B. 25(2)(a) and B. Now if you come to 25(2)(a) and B, आप घर पर देखेंगे, देखिए ये तो और स्पेसिफिक कर दिया. 25(2) I mean A and B, तो 25(2) empowers the state. 25(2) empowers the state, you see. It empowers the state, A and B. A, to regulate or restrict, I mean kindly see the bare text also. To regulate and restrict, पहला A तो यही कह रहा है ना, to regulate or restrict any economic, financial, political and other secular. देखिए, any economic, financial, political and other secular activity, you see. I mean the state can take secular steps. The state can take secular steps irrespective of caste, class, creed, religion or whatever it may be, you see. So if the authority, the state authorities, provides for a dress code, what's wrong in it? हाँ, फिर भी you have to keep the concerns or feelings of, that's another aspect. But I'm constitutionally speaking, you see. The state is empowered. A कहता है, the state is empowered to regulate or restrict any economic, financial, political and other secular activities. Secular activities which may be associated with religious practice, you see. Which may be associated with religious practice, you see. ये this is one aspect. ये 25(2) का ये A हो गया, और 25(2) का जो B है, please come to B, that is to provide for social welfare. State is empowered to provide for social welfare and reform. Social welfare and reform, and to throw open Hindu religious institution of a public character to all classes and sections of Hindus, you see. To all public character, to all classes and sections of the Hindu. तो इससे रिलेटेड अगर 25 है ना 2A के बाद B को, if you touch B, So, I mean, the relevant is Sabrimala case, you see. The Supreme Court decision on Sabrimala case. The only decent opinion was of that of, I mean, the former judge, I mean, Indu Agarwal, you see. तो मैंने कहा ना कि आप यू हैव टू कनेक्ट 3 बेसिक रिक्वायरमेंट्स. इनिशियली शुरू में ही हमने कह दिया, आई मीन 3 बेसिक रिक्वायरमेंट्स आर टू बी टेकन केयर ऑफ व्हाइल स्टडीइंग. इस लाइट में अब देखिए, अब जब द मोमेंट यू से दैट द स्टेट इज एम्पावर्ड ए एंड बी, the moment you say that the state is empowered A and B, तब तो फिर I mean है ना, to what extent it can be called constitutional or non-constitutional, I mean it is up to you to decide, you see. It is up to you to decide, it is up to the court to decide, you see. The matter is sub judice. The matter is sub judice, you see. Now, इस लाइट में है ना, if you come to this light, you see, इस लाइट में अगर आप देखिए तो you have to come, I mean in this connection, है ना, इस कनेक्शन में आपको 2 चीज, आपको अब इसका स्कोप देखना होगा. स्कोप को 1 2 3 4, आई मीन द स्कोप ऑफ. सो प्लीज काइंडली अंडरस्टैंड, नाउ यू हैव टू राइट, you have to write and you have to present, I mean the scope of article 25 हम एक constitutional law subject matter के रूप में बोल रहे हैं. इसको अदरवाइज आप नहीं लेंगे. हम तो I am talking only in the context of the, I mean provisions of the Indian Constitution. अब the matter is sub judice, let the Supreme Court decide, you see. लेकिन प्रॉब्लम ये नहीं है, प्रॉब्लम है कि आप लिखेंगे कैसे. व्हाट शुड बी योर सब्जेक्टिव अप्रोच, प्रॉब्लम ये है कि आप लिखेंगे कैसे. तो स्कोप को देखिएगा, तो स्कोप, इफ यू कम टू स्कोप, देर आर 4 पार्ट्स ऑफ द स्कोप, 1 2 3 4. तो पहला जो स्कोप है, the first scope is that this right to freedom of religion under article 25 clause 1 and 25 clause 2 A and B, and this is all talking about right to freedom, is talking about secularism, you see. तो यहां पर आप दे दें secularism, ये फर्स्ट पार्ट हो गया, है ना. Secularism in furtherance of, I mean please get my point, you see. And secularism in furtherance of, I mean the basic philosophical tool, I mean in preamble, in furtherance of secularism, in furtherance of liberty of thought, expression, belief, faith and worship. Yes, Nitin, am I clearly going on? Ask the students. Am I clearly going on? Ask the students. तो यस सर. तो कहने का मेरा मतलब है, व्हाट आई एम ट्राइंग टू से, कि सबसे पहले आप दिखाइए, आई मीन अंडर दिस हेड, सो द स्टेटस ऑफ सेक्युलरिज्म, यू सी. I mean, so the status of secularism, you see. And this secularism is in furtherance of, and this secularism is in furtherance of liberty of thought, expression, belief, faith and worship. अब यहां पर सेकुलरिज्म देखिए, दो, पहला तो पॉइंट यहां पर, द फर्स्ट इंपॉर्टेंट पॉइंट इन दिस कनेक्शन इज, यू सी, is the reference to two important case law, you see. First important point is reference to two important case law. One is Keshwanand Bharti case 1973, which came into force on 24th of April 1973. Now this is an important, very important case, you see. This was in the news also. This was in the news also. न्यूज में क्यों था? न्यूज में इसलिए था कि इसका गोल्डन जुबली सेलिब्रेशन हुआ है, 50th ईयर ऑफ सेलिब्रेशन से। तो आपको मालूम होगा, इन केशवानंद भारती, व्हाट वाज द इशू? द इशू वाज ओनली वन। हम बहुत डिटेल में नहीं जाएंगे। द इशू वाज ओनली वन, यू सी, whether the parliament has the power to amend any part of the Indian constitution including fundamental rights or not. This was the issue. Whether the parliament has the power to amend any part of the Indian constitution including fundamental rights. This was the issue. And the decision was, हम बहुत डिटेल में नहीं जाएंगे, हम सिर्फ इससे कंसर्न जो चीज है उसको बता। एंड द डिसीजन वाज, the decision was the discovery of the doctrine of basic structure, as you all know. तो जब हम कहते हैं we the people of India having solemnly resolved to constitute India into sovereign, socialist, secular, democratic republic, this line, this order of the sentence is the basic structure of the constitution, you see. Is the basic structure of the constitution, you see. तो केशवानंद भारती केस ने डेमोक्रेसी, सुप्रीमेसी ऑफ द कॉन्स्टिट्यूशन, सेकुलरिज्म है ना, फेडरलिज्म, इसको बेसिक स्ट्रक्चर माना। तो पहली दफे this has been part of the basic structure of the constitution, you see. और सेकंड जो केस है वो है एसआर बोमई वर्सेस स्टेट ऑफ एसआर बोमई वर्सेस यूनियन ऑफ इंडिया 1994, you see, wherein the Supreme Court observed, categorically observed, that secularism is the basic feature of the Indian Constitution. Secularism is the basic feature of the Indian Constitution. तो क्वेश्चन ये उठता है, the question arises, you see. सेक्युलर स्टेट का मतलब क्या हो गया? What do you mean by the expression secular state? It means three things. राज्य का अपना कोई धर्म नहीं होगा. State will not have its own religion. State will be neutral in religious matter. We are not anti-religion. वी आर नॉट इररिलीजियस, लेकिन मेरा सेकुलरिज्म 3 बात पर बल दे रहा है. स्टेट विल नॉट हैव इट्स ओन रिलीजन. State will be neutral in religious matter. State will be neutral in religious matter. And respect for all religions. Sarva dharma sambhav. And respect for all religion, you see. तो अगर कोई पूछता है ना, मान लिया क्वेश्चन ये आ जाए, सपोज अ क्वेश्चन कम्स लाइक दिस, India is a secular state. So you can write the question also. India is a secular state, but not a secular society. देखिए क्रिटिकल हो गया. India is a secular state, but not a secular society. तो सेकुलर स्टेट तो है. सेकुलर स्टेट तो है. लेकिन सोसाइटी इज नॉट सेकुलर. Appeasement policy of political parties, existence of fundamentalist organization, you see, preferences to minority institutions, politics of religion and religion of politics, you see. There are number of examples, you see, where you can write. The state is secular, but the society, Indian society is not secular, you see. आप देख नहीं रहे हैं. And this you have to attempt an answer, you see. एक सब्जेक्टिव आंसर को अटेम्प्ट करना होगा. इसको सोचिए, यू थिंक ओवर इट. यहां पर अरुणा रॉय है ना, अरुणा रॉय का एक आपको वर्सेस यूनियन ऑफ इंडिया, आई मीन अरुणा रॉय ने एक इसमें ऑब्जर्वेशन इस केस में दिया है, उसको आप जरा सुनिए, है ना. स्टडी ऑफ रिलीजन इन स्कूल इज नॉट अगेंस्ट सेकुलर फिलॉसफी. Study of religion in school is not against secular philosophy. It is susceptible to positive meaning. It is susceptible to positive meaning. That is developing understanding and respect. That is developing understanding and respect towards, and respect towards different religion, you see. तो इफ यू सी, तो ये आप देखिए, हमने सेकुलरिज्म को टच किया, हमने केशवानंद भारती केस को टच किया. आई टच्ड एसआर बोमई केस ऑल्सो. एंड द लास्ट वन इज द टाइटल जो विच कम्स विद इन द पार्ट ऑफ, which comes within the part of, I mean, scope of right to freedom of religion. तो उसमें आप मेंशन कर दीजिए, वो है एसेंशियल रिलीजियस प्रैक्टिस. वो है एसेंशियल रिलीजियस प्रैक्टिस. एसेंशियल रिलीजियस, दिस इज कॉल्ड, यू सी, दिस इज known as the doctrine of essential, the doctrine of essential and religious practice enshrined in Article 25, enshrined in Article 25. इसी को हम लोग दूसरे शब्दों में, in other words, है ना, this is known as the doctrine of essentiality. You see, this is known as the doctrine of essentiality, essentiality, which was invented by a 7-judge bench of the Supreme Court. You see, which was invented by a 7-judge bench of the Supreme Court. Supreme Court, इसी को हम लोग शॉर्ट में कहते हैं, है ना, सिरूर मट केस, सिरूर मट केस AIR 1954, है ना, wherein सिरूर मट केस, कई सारे वैसे केस हैं, कई सारे केस हैं, सिरूर मट केस AIR 1954, है ना, 1954, wherein the Supreme Court held, wherein the Supreme Court held that the term religion will cover, that the term religion will cover all, and all rituals and practices, will cover all rituals and practices integral to religion. यानी डॉक्ट्रिन ऑफ एसेंशियलिटी का मतलब हुआ, आई मीन दोज रिचुअल्स एंड प्रैक्टिसेस विच आर, आई मीन पार्ट ऑफ, विच आर इंटीग्रल पार्ट ऑफ रिलीजन, है ना, दैट हैज टू बी टेकन केयर ऑफ. यू सी, एंड इट टुक अपॉन इटसेल्फ, सुप्रीम कोर्ट ने अपने ऊपर जिम्मेदारी ली, इट टुक अपॉन इटसेल्फ रिस्पॉन्सिबिलिटी ऑफ डिटरमाइनिंग, द कोर्ट विल डिसाइड, took upon itself the responsibility of determining the essential and non-essential, the essential and non-essential practices of religion. You see, the essential and non-essential practices of religion. You see, इसी से रिलेटेड आप नीचे मेंशन कर सकते हैं, इसी से रिलेटेड चर्च ऑफ गॉड केस है, 2000 का. इसी से रिलेटेड दरगाह कमिटी अजमेर केस है, दरगाह कमिटी अजमेर केस AIR 1961 का है. इसी से रिलेटेड, है ना, कमिश्नर ऑफ पुलिस वर्सेस आचार्य, है ना, जगदीश्वर नंद अवधूत है 2004 का. इसी से रिलेटेड आपको, है ना, डॉक्टर नूरजहान साफिया केस है 2016 का. इसी से रिलेटेड है शाहरा बानू वर्सेस यूनियन ऑफ इंडिया, है ना, ट्रिपल तलाक, है ना, 2017 का. और इसी से रिलेटेड है सबरीमाला टेम्पल केस, दैट इज इंडियन यंग लॉयर्स एसोसिएशन वर्सेस स्टेट ऑफ केरला 2019 का. तो देखिए, आई मीन फ्रॉम केस टू केस, व्हाट आई एम ट्राइंग टू से, है ना, व्हाट आई एम ट्राइंग टू से, है ना, फ्रॉम केस टू केस. यू सी व्हाट आई एम ट्राइंग टू से, फ्रॉम केस टू केस. यू सी, फ्रॉम केस टू केस. यू सी, this has been determined from case to case, I mean by the Supreme Court, and determined by the Supreme Court, and the status of essential and non-essential rituals and practices, the status of essential and non-essential rituals and practice. You see, status of, है ना, status of, है ना, essential and non-essential, है ना, and non-essential practices, non-essential practices. You see, non-essential practices, है ना. So this responsibility, you see, this responsibility, so this, I mean, part of what I am trying to say, this part of right to, and freedom of religion, you see, this part of right to freedom of religion, you see, which has been, I mean, which has the philosophical base in liberty of thought, expression, belief, faith, and worship, you see. And this is actually supplements, you see. This is the, I mean, translation of, this is the actually the translation of this philosophy in the preamble. This is the translation of this philosophy in the preamble into different provisions of the Indian Constitution, you see. So time to time, if you see, time to time in this connection, time to time in this connection, this has been settled. Time and again this has been settled. That the liberty of thought, expression, belief, faith, and worship is translated into detail in between Article 25 to 28, you see. In between Article 25 to 28. Yes, online, I mean, students, Nitin, Rajiv, are you here? Online students, Nitin, Rajiv, are you here? Yes, did you get my point? Please ask the students, are they getting my point properly? Are they getting, this is in nutshell, you see, because there is a time limitation, you see. In nutshell, Nitin, Rajiv, are you here? Nitin, Rajiv, are you here? Is the students, are the students taking it seriously? Please let me know. Please let me know so that I could conclude my lecture, you see. So that I could conclude my lecture, you see. Please tell me. Yes. I mean, are the students in clear terms trying to understand? If you join this, you see, if you join this institute, I mean, through the hybrid mode, you see, you will be giving at length, you will be given at length, and you should, one suggestion to all of you, you see. Perhaps Nitin, Rajiv is not here, and there is one suggestion to all of you, that you should also arrange, because this is part and parcel of your law career, you see. You should also arrange a detailed general awareness program, you see. A general awareness program, you see. Yes, Pahuja, Ogale, and nobody is here to reply me. Is it okay? Yes, is it okay? Should I conclude? Should I conclude my lecture? Yes, is it okay? Is it okay? Yes, please let me know so that I could conclude my lecture, you see. Is it okay? Is it okay? देखो तो. Yes, please write in the chat box. Please write in the chat box. Is it okay? Yes, yes, sir. So, Kabir, is it all right? I mean, I have just, you see, in this lecture, in this, I mean, limited lecture, I have just tried to explain how to approach the constitutional law, you see. How to approach the constitutional law, you see. How to approach the constitutional law. And in this connection, I will request the management committee, you see, also, that they should also arrange, yes sir, we can wind up the session. They should also arrange, Nitin, you should also arrange at times, I mean, general awareness or general knowledge program once, because for the student this is also a very important thing. Thank you. Thank you very much. Thank you very much. Thank you very much. Yes, yes, yes. This is what I am trying to say, and I'll conclude that you should go ahead with this kind of suggestion. आप इसको इस तरह से टेक अप करें. Thank you very much. Thank you very much. Yes. Yes, sir. Yes, yes. Yes. Yes, yes. Thank you. Thank you. Thank you very much. You should you should tell you should tell your you should tell your management committee that they should also arrange general awareness program also. Thank you. Thank you very much. Thank you very much. Thank you. कैसा रहा? वही ना बोले कि थैंक यू नहीं कहा, इस पर आया है, इस पर फोन करके बताइए।